Welcome back to Justice Trail, where the courtroom reveals what's really behind the verdict. Today's case takes us into the tense world of probation violations, addiction battles, and second chances tested to the limit. Two defendants stand before the court, one pleading for mercy after repeated alcohol violations, another facing scrutiny for a broken tether and a history of What begins as a routine bond hearing quickly turns into a revealing look at accountability, relapse, and the thin line between rehabilitation and incarceration. Pay close attention, because every detail here could decide whether freedom is earned or lost again.
At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Malvo.
Judge Malvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just...
Notice how the defense is framing this. They're leaning heavily on personal responsibility and the idea of a second chance. That phrase, just one more chance, carries weight in courtrooms like this. But judges often hear it from defendants who've already broken trust. And the prosecutor, they're ready to remind the court that this isn't a one-time slip. We're talking multiple drinking incidents tied to an alleged assault with a wine bottle. That's not just bad luck, it's a pattern. What do you think? Should repeat violations still earn another shot at freedom? Or does the judge have to draw the line here?
He's just asking for one more chance, Your Honor.
Response from the people?
Your Honor, we have concerns about involved like I would note that it's not just one incident, it's on 2 different days, and that the report indicates that when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So,
and also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down.
Here's the critical point. The prosecutor isn't just recounting random dates. She's building a timeline August 19th, 24th, and 26th to establish habitual In legal terms, that's how you dismantle a defense of isolated mistakes. It paints a narrative of someone who keeps testing the limits of their bond conditions. When prosecutors emphasize repeated readings, it signals to the court that trust has already been broken. Judges take that very seriously because the bond system relies entirely on honesty and compliance. 1 violation can be forgiven. 3, that's a credibility crisis.
He also then blew and numbers on the 26th, but there aren't any other readings because he didn't take the follow-up test.
and so, Your Honor, part of the reason that we find it concerning, believe that alcohol related involved with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was a no bond warrant. He does want to move forward, Your Honor.
The defense here is attempting a classic mitigation tactic, proposing a scram. Tether as both a safeguard and a symbol of accountability. But the prosecution isn't convinced, and for good reason. Devices don't change behavior. They only monitor it. The judge even pushes back, saying, blowing into a machine doesn't do that. It's a pivotal moment. This exchange shows the tension between technological oversight and human self-control. The court must decide, does the tether represent progress, or just another layer of failed supervision?
He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though. And I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked. Defendants remanded. Your name?
Melissa Kalminski.
All right. What are we doing on this case?
Your Honor, we're asking for an adjournment for negotiations and to review videos.
You've seen the bond violation report?
Yes, Your Honor, and we have discussed it and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Konowinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which make her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so it now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof.
Now, we shift to a second case, and the tone changes completely. Melissa Kalinsky steps forward, her voice trembling but firm. She's thanking the judge for evicting her from her ex's house, calling it the turning point in her sobriety. It's rare to see gratitude toward the court, especially from someone who struggled with addiction. But make no mistake, sincerity alone doesn't outweigh a record of relapse. The judge is listening, but also weighing her words against her actions. Viewers, what's your take? Is genuine remorse enough to rebuild judicial trust?
Her letters of recommendations from
How long has she been going to AA?
She has the proof. How long have you been going?
I've been going over a year. It's a sunshine group. But since I've been out of rehab, this is what I have.
When did you get out of rehab?
I got out on the 15th,
Of what?
August.
And she does acknowledge
I
that
started drinking by the 19th.
that was one day after. And since then, she has been testing negative. She has letters of recommendations from Bear River Health and one from her boss. She volunteered in Hanover, Michigan at Rust and Dust and has a letter from there also. She realized she slipped, and for the first time, she wants this court to know she caught herself and immediately got back on track. And normally when she slips, she goes on a bender. Ms. Konowinski is asking for more time to test instead of twice a day so that she is more accountable to herself and to the court. We ask this court to recognize that she had no violations after that date and to give her another chance, especially since she has appointments set up for her mental health and for her addiction. She is also here today knowing that she could be remanded. She would also like to address this court.
Good morning, Your Honor. I first off want to thank you for back in December of evicting me from my ex's house. I'm glad that you did. I did not want it because that was a safe spot to drink. And since being evicted, things have changed. It's come into a lot in my life. I don't have to be in that household with him. And for that, I thank you very much. During the eviction, I was scared because I was giving up my way of drinking. And to this day, if I would have still been there with that man, I would probably be dead. So I thank you for giving me the eviction. And I do acknowledge and admit my part in this addiction and what I did. I'm not saying it was right, but I want to be fully honest with my recovery completely with sobriety because I don't have any more to give.
Response from the people.
This is an overview I heard with 2 priors, both in 2021. This was a hit and run crash where the defendant was then located driving a vehicle with heavy front-end damage.
This is where the courtroom atmosphere shifts from sympathy to tension. The prosecutor drops a bombshell. A prior DUI with a blood alcohol level of 0.280. That's over 3 times the legal limit. And in that case, it wasn't just about drinking. It was a hit and run with heavy vehicle damage. Suddenly, the court isn't just dealing with recovery talk. It's facing a public safety risk. The judge's patience is visible but strained. In moments like this, prior convictions haunt the courtroom, and rehabilitation arguments start to sound dangerously fragile.
She was so intoxicated they couldn't even do the field sobriety test. Eventually, her blood test showed she was a 0.280. I have no faith that she can be safe in the community right now. I'm extremely concerned that even with this gram tether, given the levels that we see in the sober lane testing, and I also know from the court, I'm sure the court's already seen it, it's towards the end of her testing window. So that leads me to have suspicion about what was it earlier in the day. I'm extremely concerned for public safety. Should she be released at all? I would ask that her bond be revoked and she be remanded. If the court is inclined to release her, I would absolutely request a scram tether. I don't think soberling is going to be sufficient for public safety.
And Your Honor, I think she would be okay with that if she did ask for more times to test so that she could be more accountable to herself and to this court.
And Your Honor, I have to go back to that. I don't think more times to test is going to be an adequate solution here with somebody that's at a 0.28 crashes, runs from the scene and has 2 priors.
Let me clarify. I was saying that she would be okay with the scram tether.
She's currently in some type of program?
She starts her program on the 22nd.
IOP, intensive outpatient.
IOP, intensive outpatient.
When?
September 22nd. She starts testing.
Do I have that? Is it somewhere in writing?
I haven't done that.
She emailed it to me. I can send it to the court.
Well, you can send it to the court along with some order. There's got to be some structure. If she's not going to be in an IOP, I can't take the chance that she's going to go on another one of these, hop into a vehicle, and this time take somebody out. I can't do that.
Well, Your Honor, she has been negative, and that was just the 1 day slip up.
Yeah, but that's all it's going to take.
I understand.
She's got, this is her 3rd.
I don't have a vehicle. Don't have a car. And I'm going to church, and I'm doing AA, and I volunteered. And I know what it looks like, but I wish people could see why I drink. To see the abuse and to see everything I went through. Well, why the hell I was living in.
I get all of that. The problem is that what's going to happen outside of the alcohol, you could potentially end up killing yourself just from the alcohol. But then all it takes is one of these slip-ups and somebody else goes. Somebody who had nothing to do with any of that abuse, had nothing to do with anything. They're all of a sudden wrapped into your world and your tragedy that you've been suffering. I get it.
I understand that, but I haven't drove in over a year, 2 years. I'm willing to go with alcohol tether, and I'm fine with that, Your Honor.
And Your Honor, she now keeps in contact with me as a support system. She calls me weekly and we talk.
And I have like letters.
Got to put together something. I'll consider it next week in terms of programming or something like that she's involved in.
Okay.
But
I do have IOP set up. I do have it set up with Medicaid rides and everything. I've been really working hard since I've been out to get back on my feet.
Going to happen again. Defendant's bond is revoked during the probable cause conference, September 4th, 2025, 9 a.m.
Yeah.
Okay, September 4th, Your Honor?
Yes.
Thank you, Your Honor.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor. As to the violation, Your Honor, my client still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike and like with the pedal, so she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in
I have
and
a
get
broken phone too. I had my number to the tether guy in my phone, and I had no way to contact.
So the tether came off in a pedal.
No, it's still on. It just pulled it and it poked it. Like there's something poking through
Did you
it.
call community corrections at any point?
That's what I'm saying. I was able to. I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my phone.
Was your tether going off?
Broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work. So
if you didn't know where to call, what were you going to do with her phone?
I was going to call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone, explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him and left a message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went off?
Well, it happened on Friday, and then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she doesn't want to comply. Have you been to the community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle or a phone at the moment, so I was requesting things through email as well, or trying to. I'm still charging it as well. Like I'm not trying not to.
She's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It seems it was just an accident, and just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So.
Yes, but I don't understand why she didn't.
She hasn't even secured a ride back yet today, so her transportation.
Well, why she didn't keep in contact more with community corrections?
I think it's due to
this thing went off almost 10 days ago.
Well, I was waiting. I'm sorry.
Go ahead.
I apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure, and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do.
Fast forward to the third and final sequence, the tether controversy. The defendant claims her ankle monitor malfunctioned while she was biking, but the prosecutor quickly catches inconsistencies. First, she says she called her mom, then corrects to visiting her in person, despite saying her phone didn't work. In courtroom analysis, we call that a credibility fracture, small contradictions that cast doubt on larger claims. The prosecution is subtly saying, if you lie about a phone call, what else might you lie about? And that single doubt can determine whether a judge sees a person trying or a person manipulating.
As far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come. And left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this
Oh,
point.
I don't.
She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI third, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people, and something I picked up on. I think the court picked up on it too.
I did.
So I'm just worried about what's going to happen.
I don't think I'm being told the truth, in all honesty.
I understand.
Your Honor, I understand, but as I said, the purpose of the tether was for her to come back to court. I'm not sure why there's concerns if she's in court here today. And she's saying that she just misspoke because she's very nervous, Your Honor. She suffers from anxiety.
Probable cause conference will be adjourned to September 4th, 2025, 9 a.m.
And there it is. The gavel falls. And once again, the court sides with caution. Bonds revoked, programs ordered, second chances postponed until accountability becomes more than just a promise. Cases like these remind us the justice system isn't just about punishment, it's about protection. Each violation, each relapse, isn't just a legal misstep, it's a warning sign of deeper struggle. But the courtroom has limits to compassion when public safety is at stake. If you found this breakdown insightful, hit that like button, share your thoughts below, and subscribe for more jaw-dropping courtroom moments and expert legal commentary.
Defendant's bond is hereby ordered revoked. Defendant's remanded.
Yeah, it was closed.